truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tuning every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces turn stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Good morning, everyone. Good morning, good morning, good morning to everyone that is here in this chat. Good morning, good morning, good morning to you guys. I have some updates. That you guys have been waiting for. Well, one of the updates has to do with Miss Fani Willis. This morning, Miss Merchant gave us a glimpse of the filing that occurred, and also the decision by Supreme Court of Georgia. It looks like Miss Willis has been denied because what she was looking for is for them to overturn the decision of the lower court, where they found her team to be disqualified to move forward with the Trump's case. So I have the paperwork, and I will share it with you guys. Just one second. My sinuses. I tell you, me and my sinuses is not fun at all. Not fun at all. So how's everyone doing this morning? Just a second. I have to download it. I downloaded it on my laptop, but my laptop is downstairs. Just one second. Just one second. Second. Just bear with me. Yeah, I know how I am. I always have to figure out how to do these things on this this computer here, because computer's just so freaking weird as heck. So I try. And you know me, I have a broken phone. That broken phone is what I usually have my stuff on. Just a second.
Our cooked steak is
I should have known I didn't have the thing the right way. The stupid phone, y'all. The stupid phone. Just a second. Just a second, guys. I know you guys are like, she's never prepared. But look, guys, I don't know how to use this stuff. I don't know how to use this stuff. So I am taking a moment to download this file. It's 30 pages, and I am trying to get this thing to you guys. Just hold on a second. All right, I got it for you guys. Okay, here we go. All right, you gotta see it. Put all these case numbers on here. All right, here we go. She requested the disqualification to be overturned by the Supreme Court. She wanted them to take a look and overturn the decision that was made from the lower courts. And then she got denied. She got denied. The Honorable Supreme Court met pursuant to adjournment. The following order has been passed. And this is for all. Let's see. Now we gotta find the look at it, the Harrison Floyd, Donald Trump, Giuliani, everybody. Randall's murder. Except the one who took the plea deal. The ones that took the plea deal, they didn't get the luxury of not being able to Where's that lady? I don't see her in here. Remember that lady, the black lady? What's it her name? Was it this her name? No, that wasn't her name. Is that her name, Kathleen Nathan? I remember her. The one that used to be all over IG. I don't see her name. Okay. The Supreme Court today denies the petition of Soteria. In these cases, all the justices concur except Ellington, McMillan, and Calvin, who dissent. Peterson, CJ, not participating, and Land and Jay disqualified. So the appeal court, this is what they said. They said that they denied Fani requests. Okay, Pinson, Justice, concurring with the denial of Centerio. I agree with the court's decision to deny these petitions for Centerio. Here's why. 1, this court's power to review cases that the courts of appeal has already reviewed, what we call review as Centerio. Somebody, how do you say that word? Give me how to enunciate that word. How do you say that word, y'all? I don't want to keep saying it wrong. Oh, I got somebody who's want my attention, lovely. They're not gonna get it. Cercheria. That's how you say it. The T you don't say the T in there. You don't say the T. Oh, okay. I know how I am with words. So you don't say the T. Certeria. You don't say the T at all. So you don't say the T at all. Cercheri. Huh? That don't sound right. Pretty chick. I don't think that's right. That don't sound right. Wouldn't you have to say the T word in there? All right, here we go. Certeri. Okay, I'm gonna say it the way you have me. Cercheri. Doesn't sound right, but okay. Oh, okay. The T is pronounced as okay, sheer. Okay. I'm just gonna say certiorari. Certiorari. Okay, certiorari. All right. We call by certiorari. I still can't say it. It's set by our state constitution. The Georgia Constitution grants our court the authority to review a by certiorari. Certiorari. Only cases in the Court of Appeals which are a gravity or great public importance. Georgia Constitution of 1983, Article 6, Section 6, Paragraph 5. This means that we generally do not grant certiorari review just because the Court of Appeals or the trial court may have gotten something wrong. This is for mere error correction. See Georgia. Certiorari generally will not be granted merely to correct or to assert error. Sancher versus Columbia County is a court case. I'm going to bypass all these court cases. Nor do we typically grant review just because a case or its subject matter happens to have found its way into the public spotlight. Instead, our focus in assessing whether a case warrants the exercise of our certiorari jurisdiction is supposed to be its potential impact on the law of Georgia. To gauge that impact, we ask whether the case presents a legal question of gravity or great importance to the public. Review on certiorari is not a right. A petition for the writ will be granted only if the case of great concern, gravity, of importance to the public. We typically assess whether a given legal question has significant gravity by asking, for example, whether the Court of Appeal has decided the question in a way that conflicts with other decision of the Court of Appeals or of this court. Answer to a legal question by applying precedents of this court that should be reconsidered or decided an important question of state law that is likely to reoccur and has not been, but should be, settled by this court. These non-exclusive example reflects the aim of certiorari review, ensuring that our court's interpretation of the law of Georgia is correct, settled, and ultimately uniform with respect to important legal issues that the courts and litigants are likely to see in the future. By identifying a legal question of significant gravity is not enough on its own to warrant certiorari review. That question must be presented by the case when it arrives at this court. Although our Constitution ensures this court with the responsibility to settle important legal questions, we are still a court, and courts are not vehicles for engaging in merely academic debates or deciding purely theoretically questions. Sons of Confederate Veterans versus Henry County. Theoretical question. Instead, we say what the law is only to needed to resolve an actual controversy. ID. Thus, even if a party has identified a question of gravity in a given case, before granting review, we still must ask whether answering that question of gravity is necessary in some ways to resolving the case. If not, the example, if answering that question wouldn't matter to the outcome of the underlying case, and if that question were not even squarely presented to or decided by the courts below, then reaching out to decide that question anyway would exceed our limited judicial role. In other words, before granting certiorari review, we must ensure not only that the petition identifies a question of gravity, but it also that the question is actually presented by the case and that answering it would help resolve the case. Number two, here, the state asks us to grant review to answer the question whether a prosecutor may be disqualified based solely upon the appearance of impropriety and absence of finding in actual conflicts of interest or forensic misconduct. In an inappropriate case, that question might warrant our review. The legal basis for a rule that prosecutors may be subject to disqualification based only on conduct that creates the appearance of impropriety is not clear. I am not aware of a specific constitutional or statutory basis for such a rule. This court only suggests that basis for disqualification as a possibility, arguable in dicta. For attorneys generally in Blumenfield and Borenstein, that decision rely on part on a sense-skewed rule of professional responsibility addressing the appearance of impropriety. CID. Cite Canon 9 of the former Code of Professional Responsibility, removed effective January 1st, 2002. Which stated that a lawyer should avoid even the appearance of professional impropriety. Georgia Rule of Professional Conduct 3-5 CMT 2. On the other hand, the idea that public prosecutors should be held to a higher standard than a private attorneys for the purpose of disqualification is not without force. It finds some support in language of some of our earlier decision. Okay, we're going to go past this one. Explaining that the administration of the law should be free from all temptation and suspicion, and public policy must emphatically demands that most prosecutors should not later appear as counsel for someone he prosecuted, because such a practice will have a tendency to greatly embarrass the administration of the criminal law. Colley versus Arnold. Stating that although we have not the slightest idea that anything intentionally wrong or unbecoming in his part was intended, it was not lawful or consistent with public policy or with sound professional ethics for a lawyer to defend the perpetrator of a battery in a civil case. Then the lawyer had prosecuted the battery criminally. See Davenport versus State, holding that public policy prohibits a district attorney from prosecuting a case while presenting the victim of the alleged criminal act in a divorce proceeding involving the accused, because under such circumstances there is at least the appearance of impropriety. Do you know what? That's why Mundo was not brought into the case, into the YSL case, y'all. You remember that? Because Mondo was represented by her, and if she had arrested Mondo as part of the YSL, then that case would have been thrown out as well, because she represented him in a prior case as a defendant. All right, let me go back. Okay. impropriety alone is grounds for disqualifying a prosecutor. Do you see that right there? It says right there, right there, right there, right there. It says that impropriety alone is grounds for disqualifying a prosecutor. Is presented by future cases we may well need to take it up in one of them. But in my review, that possibly cert-worthy question is not presented by this case, at least not at it as it appeared before this court. The root of the problem is the state's approach to litigating this issue on appeal. In the Court of Appeals, the defendants here appealed the trial court's disqualification order, which, one, found that the conduct of the district attorney and special prosecutor created a significant appearance of impropriety, and two, as a remedy, determined that one of those two prosecutors would have to withdraw from the case. In doing so, the defendant did not contest the appearance of impropriety finding, but they contended that the trial court's one of you has to go version of disqualification was error, and that it should have instead simply disqualified the district attorney. Ooh! So when they disqualified Mr. Wade, that was not the right thing to do. They should have disqualified Fani from the beginning. So you remember Wade just moved out the way? Okay. And critically, the state did not cross appeal the trial court's ruling. Indeed, the Court of Appeal explained the state asked the Court of Appeal to affirm the trial court's order in its totality, including the imposition of its alternative remedy. So, taken together, the parties' position in the Courts of Appeal poses a narrow and case-specific question for the Court of Appeals to answer. Taken as the unchallenged given both the trial court's finding of a significant appearance of impropriety and that some kind of disqualification remedy was required to cure the harm caused by the prosecutor's conduct. What was the trial court's chosen remedy an abuse of discretion? And indeed, that was how the parties argued the issue of the Courts of Appeal to the Courts of Appeal. And importantly, the Courts of Appeal legal analysis appears to have stayed within that narrow framing. In its opinion, the court explained that because the state failed to cross appeal, our consideration of the appearance of impropriety is limited to the remedy fashioned by the trial court. Roman versus State. The court went on to say that it had to address the remedy in the context of a significant appearance of impropriety caused by the conduct of the public prosecutor, which distinguished this case from private counsel disqualification cases. Emphasis added, distinguishing Blumenfeld. And the court frames its key holding as one about the choice of remedy, to concluding that the trial court erred by not disqualifying the district attorney because the remedy crafted by the trial court to prevent an ongoing appearance of impropriety did not fully cure the harm, and no other remedy would suffice to restore public's confidence in the integrity of these proceedings. In short, rather than deciding any broader question about whether an appearance of impropriety could be served as an independent grounds for disqualification of public prosecutors, the Court of Appeal decision appears to have resolved a narrow, case-specific dispute about the trial court's choices of disqualification remedy. That If that's the best reading of the Court of Appeal decision, and I think it is, that decision does not raise a question of gravity that warrant our further review. The question whether a trial court abuses discretion in choosing a particular disqualification remedy under the specific and unusual circumstances of this case is not a question of Georgia law at all, likely to arise in the future cases. Nor does the Court of Appeals fact-found decision that the trial court abuses discretion, creating an apparent conflict with decision of the Court of Appeal or this court. Thus, even if one believed that the Court of Appeals erred in reaching that decision, granting review to answer that question would be mere error correction. And this court generally does not exercise our certiorari jurisdiction merely to correct errors that do not have some broader impact on Georgia law. To be sure, it is plausible to read the Court of Appeals decision as holding more broader that. As a general matter, conduct that creates an appearance of impropriety can be grounds for disqualifying a prosecutor. At bottom, the Court of Appeal concluded that the district attorney had to be disqualified to address the appearance of impropriety found by the trial court, explaining that this is the rare case in which disqualification is mandated. One might argue that such a decision rests on a necessary premises that conduct creating an appearance of impropriety is sufficient grounds for disqualification, and in turn treat that premises as a holding. State versus Windsor. The holding of a judicial decision is more than just its result on a given set of facts. It includes, to some degree, the reasoning or principle that were merely to that decision. I disagree with that view in light of the posture of this case as it was presented to the Court of Appeals and the court's expression and repeated focus on the choice of remedy alone. But I acknowledge that drawing the line between holding and dicta is not always easy, and one's judge holding may be another's dicta. Even under the alternative reading of the Court of Appeals decision, however, I am not persuaded that this case would warrant our review at this time. For one thing, as discussed above, it is not so clear as the state suggests that there is no conceivable legal basis for holding a public prosecutor to a higher standard than a private lawyer for the purpose of disqualification, at least as a general matter. State versus Wooten. Explaining that a public prosecutor's responsibility differs from that of a usual advocate because the prosecutor represents the people and has a duty to seek justice. Explaining that the administration of the law should be free from all temptation and suspicion. And citing public policy as the basis for disqualifying a former prosecutor from serving as defense counsel based on a conflict of interest. For another, even assuming the courts of appeal has held as much such as public prosecutor's specific holding would not appear to conflict, at least not squarely, with any decision of our appellate court. And perhaps most important, it is not clear, at least not at this time, that this legal question will recur with any frequency. Appellate decision addressing attempts to disqualify prosecutors are few and far between, and only a handful of those addressed a claim that the prosecutor must be disqualified based even in part on conduct that created an appearance of impropriety. Okay, this is a bunch of case laws. Okay, let's go. Could this case change that? Perhaps, but it seems more likely to me that the circumstances in this case are unique, and I am not convinced that parties will rely on it for anything broader than the Court of Appeals stated conclusion that based on the specific findings in this case that the trial court chose the wrong remedy. And of course, if this prediction turns out to be wrong, we will have the opportunity to address the legal question about the appearance of impropriety standard for public prosecutors, even if it is properly presented in a case without the unusual procedural limitation and other circumstances that makes this case a poor vehicle for reaching that question. Members of the public may well be interested in the case underlining this petition for certiorari, but I'll focus in assessing whether to grant review under our certiorari judicial jurisdiction is on the law of Georgia. Given the party's position, the corresponding narrow question before the Court of Appeal and the court's limited resolution of that question, the decision below does not rise to the kind of legal question that warrants further review by the court under the certiorari jurisdiction. Y'all, this is a tongue tighter for me and my wordy self. I am authorized to state that Presiding Justice Warren and Justice Bethel joined in this concurrence. McMillan Justice Dissenting. I would grant certiorari because the legal issue necessarily presented here, whether an attorney can be disqualified based on the appearance of impropriety alone, affects every single active law in the state of Georgia. The Court of Appeals decisions are in conflict on this point. Our court's precedents warrants reconsideration and the issue is likely reoccur. Some background is required to understand the gravity of this issue. In 2023, the state, through the Atlanta Judicial Circuit District Attorney Fani Willis, DA Willis, charged respondent in a 96-page indictment with RICO violation and other crimes in connection with the alleged conspiracy to unlawfully change the outcome of 2020 presidential election. Respondent Roman moved to dismiss the indictment and disqualified DA Willis, her office, and Special Assistant District Attorney Nathan Wade, SADA Wade, from further prosecution based on the alleged conflict of interest and the appearance of impropriety, asserted that DA Willis and SADA Wade were engaged in a romantic relationship, and DA Willis had a personal financial interest in the case. Other respondent later filed motion to dismiss and disqualify on the same grounds. After a multi-day evidentiary hearing, the trial court found the respondent failed to meet their burden of proving that district attorney acquired an actual conflict of interest, in this case through her personal relationship and reoccurring travel with her lead prosecutor. The other alleged grounds for disqualification includes forensics misconduct are also denied. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team. In addition, the trial court noted that an odor of remains with respect to the testimony of certain witnesses. and that the reasonable question about whether the district attorney and her hand-selected lead SADA testify untruthfully about the timing of their relationship and whether underpin the finding of an appearance of impropriety and the need to make a proportional efforts to cure it. As a remedy for the financial cloud of impropriety and the potential untruthfulness, the court trial provided two options. DA Willis and her office could step aside, or SADA Wade could withdraw from the prosecution team. The trial court also denied the respondent's motion to dismiss the indictment. The respondent appealed. On appeal, the Court of Appeal affirmed in part and reversed a part of divided opinion. See Roman versus State. Relying on a leading case from the court. Okay, we're gonna go past that. The majority opinion explained that in Bloomfield, this court held that the trial's court disqualification based on appearance of impropriety due to status was improper, and that appearance of impropriety based on conduct was also generally insufficient to justify disqualification. But this court left open the possibility that the appearance of impropriety based on the conduct could justify disqualification when the interest of the public at large is outweighed and the client's interest in choice of counsel. The majority opinion explained that the district attorney's important role in the administration of justice justified disqualification because there was no countervailing client's interest in choice of counsel. Relying on this reasoning and the trial court's finding of significant appearance of impropriety, the majority opinion thus concluded that this is a rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings. ID. By this holding, the courts of appeal extended Bloomfield ruling that an appearance of impropriety alone were not only sufficient grounds for disqualification, but actually required disqualification under these circumstances. On certiorari, the parties focused their arguments on whether the Court of Appeal erred in the remedy that it ordered based on the appearance of impropriety by DA Willis, assuming as did the lower court that Blumenfeld, its prodigy, and other case law relying upon the appearance of impropriety factor in the context of attorney disqualification remain good law. I question that assumption, which in the linchpin of the Courts of Appeals decision and therefore part of its holding, State versus Weinster. The holding of a judicial decision is more than just its result on a given set of facts. It includes some degree the reasoning and principles that were necessary to that decision. Blumenfeld relied on Canon 9 of the then existing Code of Professional Responsibility, which provided a lawyer should avoid even the appearance of professional impropriety. However, effective January 1st, 2002, this court revised the Georgia Rule of Professional Conduct, removing Canon 9 and any mention of appearance of impropriety outside a comment to the rule concerning lawyers' direct appealing with tribunal. See Rule of Professional Conduct 3.5, Comment 2. Indeed, the United States of Appeal for the 11th Circuit has called the appearance of impropriety standard from the former Georgia Canon 9, no longer recognized by the State Bar of Georgia in its rule of professional conduct and outdated. In opinion that the district court properly chose not to apply it. Here's another case law. The model code has been replaced by the model rules and thus does not govern the professional conduct of attorney in the Southern District of Georgia. Under the model rules, the appearance of impropriety is not a grounds for disqualifying a lawyer from representing a party to a lawsuit. No. Other cases from our court or the courts of appeal have recognized this change in the rules or consider how it affects whether an attorney may be disqualified solely based on appearance of impropriety. The courts of appeal case law complicates the issue in that it appears to have repeatedly read Blumenfeld to require an actual impropriety or conflict of interest to accompany the appearance of impropriety to warrant disqualification, though that rule, whether right or wrong, has never actually been announced in our cases. Our Supreme Court has held that absent of actual conflict of interest and actual impropriety, the trial court does not abuse its discretion in denying a motion to disqualify counsel. Absent of actual conflicts of interest and actual impropriety cannot say that the trial court abuses discretion in denying plaintiff's motion to disqualify. There must be proof of an actual impropriety to disqualify an attorney from representing a client. Although then Judge Land's dissenting opinion cited Georgia trial and camera for the proposition of that a conflict of interest or actual impropriety is required for disqualification, the Roman majority explicitly did not cite or address any of these cases, even though they were binding to that court. White versus State. Okay. The Court of Appeal was obligated to continue to rely on the older precedent from that court until such time as the older law was properly overruled by the court or reversed or overruled by this court. The issue is whether Blumenfeld remains good law and whether the appearance of impropriety alone can support the disqualification of an attorney in a question of gravity. Supreme Court Rule 41 provides a petition for the writ of certiorari will be granted only in cases of great concern, gravity, or importance to the public. Such cases may include those in which a decision of the Court of Appeal or an important matter is in conflict with other decision of the Court of Appeal or decision of this court, or b a decision of the Court of Appeal on an important matter faithfully applies a decision of this court, but this court's precedent warrant reconsideration, or c the Court of Appeal has decided an important question of state law that is likely to reoccur and has not been but should be settled by this court. These petition meets the definition of gravity under subsection A, B, and C. To begin, the issue of whether the appearance of impropriety alone can justify disqualification of an attorney affects every single active lawyer in this state. This qualifies as an important matter under Rule 40. And as explained above, the Courts of Appeals' decision on this issue are in conflicts. See Supreme Court Rule 41A. Likewise, the Roman majority purported to apply and extend Blumenfeld, but Blumenfeld warrant reconsideration given the removal of the appearance of impropriety. Standard of our Code of Professional Responsibility over 20 years ago. See Supreme Court Rule 41B. Finally, the question of whether the appearance of impropriety alone can justify disqualification of an attorney is an important question of state law that is likely to reoccur and has not been, but should be settled by this court. Supreme Court Rule 41C. Most states, like Georgia, have patterned their lawyer ethic rule on the model rule of professional conduct, including its deletion of the appearance of impropriety standard. Many of those states have subsequently rejected the standard and do not apply it in disqualifying cases. All right, these are all case laws. Most state, however, continues to apply the standard as a factor that may be considered in deciding disqualification, but that is alone insufficient to warrant disqualification. And here's some more case laws. Other states have concluded that an appearance of impropriety can be sufficient by itself to justify disqualification. Okay, I gave some more case laws. Okay, we got some more case laws. We got to go. All right. Noting the appearance of impropriety survives as part of conflict of interest. Analysis in disqualifying proceeding, but it is simply to slender a reed on which to rest a disqualification order, except in the rarest cases. And even this rough grouping of case laws from different jurisdictions remains questionable in several instances, and the state of law on the issue of invariance in various jurisdictions being confusing and even inconsistent. Such much make the state of our own law on the issue. I note, too, that several states treat this issue differently depending on whether it arises in civil or the criminal context. This survey of other states demonstrate that this issue is an important one that is likely to reoccur, and given the wide variety of approaches, such should be settled by this court. Adding even more gravity, this is also an issue that is likely to reoccur with respect to prosecutors across the state, in particular because of the recent passage of OCGA 17-11-6, which provides the event that 1. The prosecuting attorney in a felony or misdemeanor criminal case is disqualified due to improper conduct on the part of such prosecuting attorney, and 2. Such criminal case is dismissed by the court or a subsequent prosecutor tasked with prosecuting such case following such disqualification. Any defendant against whom which the charges are dismissed shall be entitled to an award of reasonable attorney fees and costs incurred by the defendant in defending the case. As such, there is now a financial incentive to move to a disqualifying prosecutor. Indeed, a review of the legislative history of that bill shows that although opponent primarily concerns centered on the partisan politics surrounding the bill and the prosecution underlying a specific case on Syrian review here, one of the concern expressed was that the law would be abused in future cases, having a chilling effect on criminal prosecution. See House of Session Day 39, April 2nd, 2025. And the Court of Appeals opinion added that the incentive to assert an appearance of impropriety to disqualify a prosecutor because that standard is amorphous and likely easiest to meet. See Arkansas Valley versus State Bank. Okay, that's a That's a case. Okay, quoting part of John W. Castle's two. Okay, that's a case law. Sorry. Let me go down. Disqualifying. Okay, we're not gonna go there. Okay, let's go to. And noting that some courts have dropped the appearance of impropriety as a basis for disqualification, largely due to the fact that when the American Bar Association proposed the model rule of professional conduct, Rule 1.7 was drafted specifically to remove the appearance of impropriety test because the test was deemed too vague and presented a severe problem. Okay, we got case law here. The law of lawyering in describing the appearance of impropriety standards is nebulous and rejected by most court as a sole basis for disqualification. Okay, we've got case law here. We acknowledge that in order, disqualifying counsel may impose significant hardship on litigants, and we share the courts of appeal concern about tactical use of disqualification motion to harass opposing counsel. The tactical use of attorney misconduct disqualification motion is a deeply disturbing phenomenon in modern civil litigation. No doubt, the fact of these cases are unusual, and the cases are politically charged due to the subject matter and the parties involved, including the current president of the United States. But neither the unusual underlying facts nor the identities of the parties privy these cases of gravity. This is because the legal principle underlying the courts of appeals ruling, in particular, the proposition that the appearance of impropriety alone can warrant and even require disqualification are not bound to this specific factual scenario or to these specific parties, but will instead apply to a wide variety of situations in which a litigant can show only an appearance of impropriety. And those situations are likely to reoccur with more frequency. In short, this case requires the resolution of a novel issue of gravity, which the state of the law is confused and conflicted, both in Georgia and across the country, and thus warrant consideration or reconsideration by this court. Moreover, the issue affects the bench and bar across the board, and will likely reoccur such that guidance from this court is desirable. Therefore, I would grant censure to resolve the issue of attorney disqualification based solely on the appearance of impropriety, and would propose the following questions. 1. The extent Georgia appellant case law permits disqualification of an attorney solely for the basis of impropriety. See Blumenfield and Borenstein. Does that remain good law following the adoption of 2001 Georgia law of professional conduct? 2. If not, what is the legal basis for disqualification of an attorney solely on the basis of appearance of impropriety? 3. Did the Superior Court abuse its discretion by denying the motion to disqualify even though the court found a significant appearance of impropriety? I authorize the state that Justice Ellington and Colvin join in this dissent. All right, that is it, y'all. That is the outcome. All right, it's about time. She's told no for her shenanigan. Okay. All right. What do you guys think? It was very like all over the place, but They came out to the right decision because, I mean, it is what it is, y'all. It is what it is. She got rejected. And it was, come on, y'all. It was some impropriety. We saw it. We saw the impropriety. We saw it. We saw the conflict of interest. I'm sorry, y'all. I'm eating my mango. Sorry. I couldn't wait to eat my mango because I was reading it and my throat was getting dry. I was falling all over the words and stuff. So I had to get my mango. All right, Mr. Podcast with Soul. Oh, I got some news too, Mr. Podcast from Soul. Did you see it? Did you see the new lawsuit by that young lady who did it pro se? No. We on one topic, he on another topic. We're going to do Puff in a few. You're all on a different topic. We're not on Puff topic right now, sir. We're going to do Puff later on. But we're doing Georgia stuff right now. Look at him, y'all. He on a roll in here. Look at him. He's doing advertisement. You know, he say his thing and then he move on. He'll be gone in a second. Y'all say 5, 4, 3, 2, 1. He gone. I bet you. He'll be gone. Shout out to Podcast for Soul. We're going to be out there together in New York. In New York! Okay. Well, my darlings. Oh, I got some news for you guys in regard to Mr. Steele's case. I will be going live and talking to you guys about that. So, any questions, y'all? Any question as I enjoy my mango? This mango is so good. Any question? Hey, Ann. Any question, y'all? All right. So, should I enjoy that mango? I am. I'm enjoying it. It's so delicious. Look at my mango. Okay. Well, I can go ahead on and talk about this case here. Or should I just wait? You guys tell me, what should I do? Should I do another live? Or should I just go ahead on and tell you guys my news on this one? think I'm gonna do another live. But I gotta go, y'all, because I gotta go to all the way out to perimeter. Do another live. Okay, I will do that. I gotta go out to perimeter. I'm doing a focus group. All right, I'm gonna do another live. All right, I'll see you guys in a few. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click